Hi everyone, and welcome back to the All on the Line North Carolina Redistricting Leadership Program. Today, as you can see on the course outline, we're going to be talking about the Voting Rights Act and the case Gingles versus Thornburg. So, how we're going to walk through this. First, we're going to talk about the role that the Voting Rights Act plays in redistricting specifically. And then we're going to go into a little case study about the 2011 so-called VRA districts and how those two things work together there. We will then explain the Gingles Test, which is a test for majority-minority districts that comes out of the Gingles versus Thornburg case. And then we'll spend some time sort of tying together all those things, and then we'll have a few key takeaways at the end. All right, so the VRA and redistricting. The Voting Rights Act obviously is a really big landmark piece of legislation that made a lot of changes to laws in this country and had a huge effect on voting rights in general. And there's a lot that you could say and research about it. But today I'm just confining myself to the effect that it has on redistricting, just because there's so much, and that's the thing that you are going to need to know next year to participate in the redistricting process. So, why do you need to know this? So in the past, in North Carolina, especially in 2011, the Voting Rights Act, and which was something that was created to reduce barriers to voting for people of color and especially Black people. In the past in North Carolina, it has been basically exploited in order to pack Black voters into the fewest number possible of districts in order to minimize their voting power. And so if you know about how the Voting Rights Act is meant to work, you will be able to tell when the VRA is being used improperly to do these things to reduce especially the influence of Black voters, because that's how it's been used in the past here. And also, if you know that and you can identify it, in the case North Carolina versus Covington, where some racially gerrymandered districts were overturned, statements made at public hearings about how the VRA was being misused were actually important pieces of evidence in that case, and the case was ultimately successful. All right, so the section of the Voting Rights Act that is the most relevant to redistricting is Section 2, and Section 2 states, "No voting qualification or prerequisite to voting or standard practice or procedure shall be imposed or applied by any state or political subdivision to deny or abridge the right of any citizen of the United States to vote on account of race or color." So what does that mean in practice? So in practice, Section 2 provides for the drawing of majority-minority districts in order to prevent the dilution of a minority community's vote. So to make sure that that minority community can elect candidates of its choice and it's not constantly being overwhelmed by the majority, usually white people, that Section 2 allows for that minority to have districts where it is the majority. So basically, majority-minority district is a district where that minority group makes up a majority of the voting age population in that district. And just a note, while this was originally only applied to race, in 1975 the act was updated to include language minorities. In a lot of other states, it has been used to protect the rights of Latinx people and Native American people, but in North Carolina it has definitely been primarily used for majority-minority Black districts. And here's a little graphic that Daily Coast put together about, they speculate that we could have actually had more of these sort of Section 2 districts in our congressional seats than we have had. All right, so let's go into this case study about the 2011 so-called VRA districts. So if you listen to the last lesson on Stevenson v. Bartlett, you know that part of the decisions that were made there basically said that if there are majority-minority districts that are drawn under Section 2 of the Voting Rights Act, they have to be drawn first, and because they don't have to comply with things like the whole county provision that's in place in North Carolina. If you don't know what the whole county provision is, you can look at the last lesson. But so VRA districts are generally drawn before any other districts, and so that's sort of the context for this. So in 2011, The redistricting process was controlled by Senator Bob Rucho and Representative David Lewis. David Lewis is still in the legislature and is likely to control the redistricting process next year if Republicans still control the House, and Senator Rucho has retired since. But while they were in charge of that process, when it came to the quote-unquote VRA districts that needed to be drawn first, the way they went about it was they told Dr. Thomas Hoffler, who was the consultant who they hired and who has been basically famous for assisting partisan and racial gerrymandering in lots of states in this country. They told him, we want you to draw a 50% plus one district wherever in the state there is a sufficiently compact Black population to do so. So anywhere in the state where you could possibly draw a majority minority Black district, you should draw it. Right? That was the sole consideration. That was the only thing they were thinking about. So Thomas Hoffler did that. He drew every single majority Black district that he possibly could. And you can tell from the shape of some of these districts that compact is a little bit of a stretch. So after these maps came out, because these were the first districts drawn, they were also the first districts that were made public and filed as bills in 2011, and there were a special set of public hearings just about these districts. And during those public hearings and also during debates in the legislature, legislators and members of the public basically questioned the justification for how this was done, right? They said, drawing a 50 plus one Black district everywhere you can, that doesn't seem like it's closely tailored to the object of making sure that minorities have representatives of their choosing. That's not really how you would go about it. That's not a sensitive way to do it. And there were allegations at the time where legislators especially said, we think that this may be, the purpose of this may be to pack Black voters. Because the only consideration that was made was just the number of Black voters in that district and nothing else. However, when these questions were brought up by the public and other legislators, basically Senator Rucho and Representative Lewis said that they were just doing this because they were following the law and they didn't want to get sued under Section 2 of the Voting Rights Act, and so they were doing this because it was necessary so that they were adequately following the Section 2 of the VRA. That's what they said. They were wrong. They were wrong about that. The court determined they were wrong about that. And also, if you didn't grow up watching like Murray when you were sick at school, at home for the day, then like we have a lot less culturally in common than I would hope. But so the so-called VRA districts that Rucho and Lewis drew were almost all invalidated by a federal court in the North Carolina versus Covington case. So clearly they were not actually foreclosing a lawsuit about racial gerrymandering. So, but why were they thrown out? So basically the Covington court opinion said that when they drew these districts, they were not using the factor of race in a way that was reasonably necessary to make sure they weren't violating Section 2 of the VRA, right? They weren't actually using race to tailor districts to a situation where minorities, especially Black people, were underrepresented. So, and the reason that the court could say this and say that these districts were racially gerrymandered was primarily because they did not meet the standards put in place by the Supreme Court case called Gingles versus Thornburg. And here's a cool graph from Mira Bernstein that shows sort of some of the effects of number of Black congressional representatives after some of these decisions. And you see this huge spike after Thornburg versus Gingles. Thornburg versus Gingles, Gingles versus Thornburg, they're both fine for, most normal purposes. So I think people kind of can generally use them interchangeably. All right, so let's talk about Gingles itself and the test that comes out of it. So the Gingles versus Thornburg case is a case where the plaintiffs were challenging the state legislative districts that were drawn in 1981 on the basis that they diluted the Black vote. So if you recall, back then we had lots of multi-member districts, which naturally dilute minority votes, and all kinds of other weird things were going on in our maps at that time. but those were the maps that were challenged. And the U.S. Supreme Court agreed that most of the districts that were challenged violated Section 2 of the Voting Rights Act by diluting the minority vote. And so in that process, the court established a test to determine whether or not the drawing of a majority-minority district was valid in that area. So, the question sort of was, okay, black votes are being diluted, so we need to make sure that doesn't happen. So when do we know that we are supposed to draw a majority-minority district that complies with Section 2? How do we know? So that's why they established this test. And this is a picture of Supreme Court Justice William J. Brennan, who wrote the opinion in the Gingles case and is a super influential progressive Supreme Court justice. All right, so here is the actual Gingles test. So it established the following 3-point test to assess whether a majority-minority district was required by Section 2 of VRA. So do we need to draw one? So here are the 3 factors. The first factor is the minority group has to be big enough to be the majority in a single member district. So there have to be enough members of that minority population that they could actually make up the majority of a district. So, district sizes are regulated by the number of seats and the number of people who live in, say, the state. And so when we know that number, we know how many people we would need to have a majority for a single district. So does the minority group make up that number? Second thing, the minority group has to be politically cohesive. So the people in that minority group have to mostly vote for the same candidate. So if there is like a black population that could make up that majority, it has sufficient population to do so, the members of that population have to usually vote or mostly vote for the same candidate. So they're politically cohesive. The third factor is that the majority, so in most cases this would be white people, so the majority in that area where the district would be drawn also is politically cohesive and votes together as a block in sort of a sufficient size that it would usually defeat the minority group's preferred candidates. So say you have a district where there is a majority of white people and a smaller minority of black people, and the black people in the district, most of them vote for a black candidate, and the white people in the district mostly vote for a white candidate. That majority is always going to overwhelm the number of votes coming from the minority community, so the minority community will not have an opportunity to elect a representative of their choosing. So you have to have that sort of, they usually call it racially polarized voting, where different racial groups tend to vote differently as blocks, is also the other sufficient condition for a majority-minority district under Section 2 of the VRA, under this Gingles test that was established in 1986. All right, so let's tie some of those things together. Let's tie that sort of case study about 2011 and the Gingles test itself together and, have some thoughts. So, Gingles was in effect in 2011. So the Gingles 3-factor test was the standard for majority-minority district compliance with the VRA from 1986 on. So it had been in place for 25 years when those quote-unquote VRA districts were drawn in 2011 by Rucho and Lewis. So when Rucho and Lewis were saying that they were just following the law and that the districts were necessary to foreclose any Section 2 lawsuits, they were, at best, just incorrect because they weren't following the Gingles test. So why didn't they follow the Gingles test? Because without a Gingles analysis, there was no real proof that the so-called VRA districts that Rucho and Lewis had drawn were actually in compliance with the VRA. And to me, that raises the question of what were their actual motivations in drawing them? Because you would think that this test has been around for 25 years. Everyone should know about it, especially people who are in charge of redistricting. I mean, they know this stuff. So if they really were trying to draw these districts to comply with the VRA and prevent lawsuits, why didn't they undertake an analysis that had been settled interpretation of the Voting Rights Act for 25 years? So what were they really trying to do? Well, one thing I will say is that the Covington court declared most of these districts to be racial gerrymanders, so, you know, I guess Kermit sort of sums up how I feel about that. All right, so what are the key takeaways for this lesson? If that happened in 2011, if those quote-unquote VRA districts were used to create racial gerrymanders to minimize the influence of black voters in 2011, it will most likely happen in 2021. Using the VRA as a cover to pack black voters was one of the signature sort of innovations of Dr. Thomas Knopfler. But even though he's gone, it doesn't mean that's over. It's likely that because of the way the Covington case went, legislators will be a lot more wary and covert and sneaky when they do try to racially gerrymander districts in this way with the VRA as a cover, but I don't think it will actually stop them. But you can make a difference in that. So the reason it's important to know about how Voting Rights Act majority-minority districts actually work and what the Gingles Test requires is because when they do it again, which they probably will, you will know how to spot it and how to question it in public. And maybe something that you say when you question it in public will make a big difference. There were all those people who made public comments against those quote-unquote VRA districts in 2011, and those quotes were used in evidence in the case that ultimately overturned them and found them to be racial gerrymanders. So the things that you say in public can have a huge impact and influence. And that's why you need to know this. And so that is like the core of this lesson, is everything that we're trying to do here is teach you the real skills you need to know. And this is one of the main ways that especially black voters in North Carolina have their votes subverted. And so now you know how to identify it. All right, so that is the lesson for today. And I hope that you enjoyed it. And always, if you have any questions, please email me. My email is in the syllabus, so you should be able to get in touch with me and ask me any clarifying questions, or if there was something you don't understand, I'm so happy to talk to you about it. Our next lesson is going to be another one of our deep dives. So we did a deep dive into the 2011 process itself, and if you listen to that, probably a little bit of the stuff that I covered here was sort of a rehash. But we're going to do another deep dive on the gerrymandering lawsuits that took place from 2011 to 2018. So like always, the deep dive is not something that is essential to you if all you want to do is make sure that you're the most effective and smart advocate in the redistricting process next year. But if you're someone who does want to dig deeper, who thinks this is just interesting, who's a little bit of a redistricting nerd, you will really enjoy these deep dive lessons. So that is what our next lesson is going to be, and I'm looking forward to it. So hopefully I will see you all soon.